Our first speaker tonight on our topic of Medicare and Medicaid, Social Security benefits, and other public benefits is Karen Warren. She just got promoted at Legal Services of Eastern Missouri. I'm not sure what her new title is. She and I used to work together.
Sure did.
She really knows her stuff on this topic. We're very appreciative that she took her time out to be with us. And some of you may be aware Legal Services of Eastern Missouri is a local legal aid office that provides free civil legal assistance to low-income persons. So that's where she works. I'm going to go ahead and let her get started. During the break, if you weren't able to pick up your certificate, they got all out of order. I'm going to try to put it back in order so you can come up and see me if you don't have your certificate.
Okay. Thank you, Jen. Can everybody hear me okay? Okay. Like Jen said, I work at the local legal aid office, Legal Services of Eastern Missouri. We're located at 4232 Forest Park Avenue here in the city, and we've been in existence for over 60 years. I just switched to a new position, which is Associate Director of Administration, and I'm really excited about it. But prior to that, I had worked for a number of years as the manager of our public benefits program, which encompasses Medicaid and Medicare as well as other state-administered public benefits. So I was really happy that my friend Jeff Bunten, who will be our second speaker tonight, that's going to cover Social Security and VA benefits, asked me to co-present with him. So I will do my best not to put you to sleep. I appreciate that you came out in the weather with all the rain. And so I had two handouts and a copy of my PowerPoint that should have been given to you. I'm going to be working from the PowerPoint. The handouts are just kind of a supplement to give you a little bit more information about some of the state-administered Medicaid programs. I understand I have 50 minutes. I'm a really big talker, and I do tend to talk very quickly. So if you miss something that I say, just say, hey, Karen, I didn't catch that. That's fine. I'm not real formal. I just kind of look at this as a conversation. I am excited to share with you my knowledge. I've been practicing since 1994. Though I may not look like that, but I have been a practicing attorney since 1994. Okay, so we're going to get started. And I gave you a few objectives for my talk today, and really I just want you to leave here feeling like you have a sense that you better understand what Medicaid and Medicare are about and how they could impact you. Maybe some of you are already Medicare recipients. I will say that I may not be able to answer really specific personal situations just because you will hear this a lot from attorneys that it really depends on the circumstances, and we really need to have all of the facts to be able to give you good information. So tonight I just want to give you a general overview, and hopefully this will give you some time to kind of think things over, and then if you have other questions, then you know what to do next to try to get answers to those questions. Does that make sense? Okay. So here's our agenda for this session. It's kind of jam-packed, and I have 50 minutes, so I'm just going to take a breath. And I'm going to do my best, because both of these programs that we're talking about tonight have been around for a very long time, and they are extremely complicated. And I don't say that just because I'm a lawyer and that's what my life is like, but I've spent a lot of time working with these programs, mostly the majority of my time Medicaid, but these are very heavily regulated programs, and as with all laws, things start with the law, but then we have other things such as regulations and policies that executive branch agencies use to administer these programs, and that's what makes them a little difficult sometimes for people to comprehend. So let's start out with what are Medicaid and Medicare. Both of these are health insurance programs. They're, to me, the two biggest health insurance programs that I know of. That first definition that I gave you is how Karen views these programs, which are programs that are designed to meet the medical needs of specific populations, and they're administered by the federal government, that is the Medicare program, and state governments. Medicaid itself is a joint federal and state program, and we'll talk about that. What I've noticed in my time practicing is that a lot of people think that these two programs are one and the same. They are not. They're two distinct programs created by the same law, the same act, but they have separate rules, regulations on about how they are administered. So Medicaid, as I said, is a joint state federal and state program. And actually, the Medicaid program itself is a voluntary program. No one ever told the states that they had to participate in that program. States can choose whether or not they want to participate in Medicaid. And if they have a state Medicaid program, the important thing to remember is that there's a set of federal regulations that every state has to abide by, because there are certain conditions, certain services that are mandatory that they have to provide to Medicaid recipients. So right now, about 72.5 million Americans, including children, pregnant women, and parents, and seniors, and individuals with disability, get care through the Medicaid program. It's the single largest source of health care in the United States. Medicare, on the other hand, is solely a federal health insurance program, and it's designed specifically for people who are over the age of 65, certain younger people with disabilities, and people with end-stage renal disease. You'll find that there's two qualifying conditions for Medicare, irregardless of age, one being end-stage renal failure, the other being Lou Gehrig's disease. So now a little bit of history for you. Medicaid and Medicare were created by House Resolution 6675, and that bill was signed into law over 50 years ago in 1965 by what president, do you think? All right, oh boy. And then these two programs were created through that particular act, and there's been some amendments to them over time. I don't, unfortunately, have enough time tonight to go over the specific amendments. I will talk about one specific amendment on the next slide. So President Johnson signed this into law in Independence, Missouri. So the first person to enroll in the Medicare program was, who do you think? Harry Truman. What did you guys study before you came? I thought I was going to tell you something you didn't know. So Medicare is designed for individuals who are 65 or older. Medicaid, on the other hand, is, in my mind, a broader program. It's not necessarily age specific, and we're going to talk about some of the qualifying criteria for Medicaid, but it was specifically designed, to address the needs of low-income individuals, the indigent or the poor, who did not have a source of health insurance. So that's the purpose of Medicaid. Now, a later amendment to the Social Security Act affected Medicare, and it expanded Medicare, and this is the one amendment I'm going to discuss, and Jeff may touch on this in his presentation, and that is for individuals who have been determined disabled by the Social Security Administration and have received those benefits for 24 months. After 24 months of receiving those benefits, they are entitled to coverage under the Medicare program. So these next couple of slides, I'm not going to get into a whole bunch of detail, but I thought you may find it interesting to actually find out how these programs are indeed funded. So Medicaid, remember I told you, is a joint state and federal program. If states are going to participate in the Medicaid program, they have to be able to put up a certain amount of the money to operate it. And so they're responsible for certain expenditures, a certain percentage. And then what happens is that the federal government matches that. And so that is called the FMAP, or the Federal Medical Assistance Percentage, and it varies by state. They have a specific calculation on how they do it. I'm sorry, I cannot explain that myself. I'm not on this end of Medicaid, I'm on the other end of Medicaid, which is helping people qualify and get benefits. But they do. In Missouri, 63.21% of was the FMAP for Missouri in fiscal year 2017. So what that means is that for every dollar Missouri spends on coverage, the federal government provides $1.72. Okay? And currently, more than 990,000 Missourians have health care coverage through the Medicaid program. Medicare, in comparison, is funded by two separate trust funds. And you'll see there first, the one is the Hospital Insurance Trust Fund, which is funded by payroll taxes, income taxes paid on Social Security benefits, and interest earned on fund investments, and Medicare Part A premiums. And the second is the Supplementary Medical Insurance Trust Fund. And that is the second trust that funds Medicare, and it's funded by appropriations from Congress, Part B and Part D premiums, and any interest earned on fund investments. Somehow I'm not clicking this right. Oops. There we go. Key terms for our discussion. Just so you know what I'm talking about, I try to avoid jargon as much as possible. But so I gave you my basic definitions there. You might want to refer back to them. But I think for purposes of tonight's talk, I think everybody's going to know when I say applicant or beneficiary what I mean. But really, if I say CMS, I'm talking about the Centers for Medicare and Medicaid Services, which administers both of these programs, which is based in Washington, D.C., the Missouri Department of Social Services, which is the state agency overall that's responsible for the Medicaid program. And then there are two what I call sub-agencies, the Family Support Division and the MoHealthNet Division. So the Family Support Division is one, it used to be called Division of Family Services, you all have heard of that. They determine eligibility for all state administered benefits. And then the MoHealthNet Division is important here for Medicaid purposes because it is like it's the financial arm. It's like an insurance company. They're the ones that get the claims filed from medical providers and hospitals, and they have a way of processing those claims, and those claims are either paid or they're denied. So they pay the bills, okay? Both of those are based in, well, the department overall is based in Jefferson City, Missouri. That's the main central office. But by law, the Department of Social Services is required to have a presence for the Family Support Division in every single county in the state of Missouri. So I don't know if you know that. But I used to work for the Department of Social Services years ago, basically when I first started practicing. And at that time, I worked with our administrative hearing section and then some with our Office for Civil Rights for the Department of Social Services. It's a very large agency, so it takes a lot of coordination to be able to screen people for eligibility. So how do you become eligible for Medicaid in Missouri? There are some basic eligibility factors that are common to every single applicant. And we're going to talk in a minute about how Medicaid itself is this broad program. And I like to think of it, I've tried to explain it in other talks about how it's like an umbrella, and there's all these different sections of the umbrella. Because Medicaid is not just for people who are elderly, it's not just for people with disabilities, it is for women, it's for children, it's for families. It has expanded since its inception in 1965. So there are a few criteria that an eligibility specialist at the Family Support Division is going to look at when a person applies. And they get that information because the person files an application. Generally, it's an individual that's applying. It may be a person is in the hospital and they're sick, they lack insurance, and so they're uninsured. The hospitals often have financial counselors that will come around and help uninsured patients file Medicaid applications. So sometimes that happens. It can happen when someone goes into a nursing home and say they had some money set aside to pay for nursing home care, but then they exhaust it, and at that point they don't have a means of paying it. There's a category of Medicaid that people use for nursing care, and so sometimes social workers in nursing homes will help individuals, residents of nursing homes, apply for Medicaid, okay? So we're going to look at residence and household composition. So you need to be a resident of the state of Missouri and intend to remain here. They're going to look at age because that can be an eligibility factor. They want a social security number. They also want to know that you're a citizen or you have a lawful right to be in the United States. So what they call, that's their terminology, qualified aliens. And so there's different categories of people that would fall within that. More often than not, it's someone who's a lawful permanent resident. It could be a refugee or an asylee, but there's some limitations on when someone who's a non-U.S. citizen can get Medicaid. So just keep that in mind. We could have a whole discussion about that. There's a whole policy on it. They're going to look at income, and then they're going to look at cash and securities, real property, personal property, life insurance, and pre-need burial plans. The ones with the asterisk by them are there because depending upon the category of Medicaid, those may or may not matter, okay? But I will say that generally speaking, with all public benefits programs, there is a needs-based requirement. There's a financial element to them. So in Missouri, Medicaid is called MoHealthNet. Long time ago when I first started doing this work, it was called medical assistance. Then they decided, okay, we're going to call it MoHealthNet. So anytime you see MoHealthNet before something, just think that's a Medicaid program. So it's going to be targeted, most Medicaid programs, as I mentioned, are targeted towards specific populations. And tonight I'm going to talk about the two populations that I have the most experience in dealing with. And I think that will be relevant for you to know, and then I can mention some of the others. So each of these populations participate in a unique MoHealthNet program, and they all have program-specific eligibility criteria, including the common criteria that we covered in that prior slide. And as I said, FSD determines the eligibility. So when you apply for Medicaid, you have a couple options in your application, the way you apply. The applications are available online. I have a list of resources at the back that we'll talk about when I wrap up. And you can get those Medicaid applications online, fill them out. You can go and visit your local Family Support Division Resource Center, which is what they call most of them now, and go and file it in person. You can mail it in. It can be faxed in. So there's a couple options. Some of the programs allow you to submit the application online. For the ones that I know most about, I don't think they still have that feature available. Also, I wanted to mention, do any of you in your spare time like to go and just read the revised statutes of Missouri? Jeff and I spend a lot of time with them. But that's the state law, that's what it's called.
Where can we find them?
You can go online, actually. If you go into Google, you know, everybody loves Google. You say, Google, let me ask you. So just go in and put revised statutes of Missouri. And for the Medicaid program, the chapter of the law that's going to apply is Chapter 208. It's called Public Health and Welfare. And to get started with your reading, so are you going to go read that tonight?
No, but I have done some research in the city.
Yeah.
I don't know if I found out that there's roughly 5,000 births in St. Louis every year. And of that, roughly 69%, or about 3,500 of those births, go on Medicaid every year.
Okay.
These are girls that are unmarried.
Okay.
Usually they haven't finished their school, they don't have a job, they don't have insurance, and they're unmarried.
Okay.
So they don't have another means of support.
Yeah. So if you look in 208, if it's 208-001, that is the beginning of that chapter. That's going to talk about medical assistance, and it'll talk about medical assistance or Medicaid or MoHealthNet, and it'll talk about some of the other benefits programs, okay? So the next slide shows you the different variations of Medicaid programs. MoHealthNet for seniors, MoHealthNet for kids, which is called the Children's Health Insurance Program, which was one of the Medicaid programs that has since expanded over time. So they moved away from the original purpose of the law, which was to help low income, like seniors and people with disabilities, and it's been expanded some. MoHealthNet for the blind and visually impaired, which is really blind pension and supplemental aid to the blind. These are kind of programs that are unique to Missouri, and they're state funded, and there's a very strict visual requirement that someone has to meet in order to get these benefits. It is not enough to be legally blind in order to get this, but if you get this benefit, then you will get Medicaid coverage in a small cash grant. MoHealthNet for people with disabilities, MoHealthNet for pregnant women and infants, MoHealthNet for families, and then there's a group of programs that we'll talk about later, that shows how Medicaid and Medicare are related, called Medicare Cost Savings Programs. And then MoHealthNet for nursing care coverage, which I was talking about the nursing homes. We call it vendor coverage, okay? So these are the general categories. The one that I'm gonna talk about is called MoHealthNet for the aged, blind, and disabled, which is really a combination of that MoHealthNet for people with disabilities and MoHealthNet for seniors. So there's basically 3 categories and 3 ways to be eligible here, except for I take it back, two categories on this particular slide, because I'm not covering the blind pension part, the visual part. So you see up at the top that OAA, this was called Old Age Assistance. That is what that acronym stands for. That means that you have to be 65 years of age or over or older to get Medicaid. You have to reside in Missouri or intend to remain here. And then you can't reside in certain public institutions. So an example of that would be like you cannot be in prison or a penal institution. Basically a state-supported facility where you're getting medical care already. And then there's a resource limitation. They're going to look at property transfers. It's investigated, but it doesn't really matter so much for this particular category. It matters more with the nursing home category. The Social Security number, the citizenship, and then in this instance for old age, it doesn't matter whether or not you have a disability. You qualify based on your age alone, but you cannot get Medicaid if you have resources that are over that amount. So if you're a single person, you can't have any resources that equal $1,000 or more. And if you're a married couple, you can't have any resources that are over $2,000 or more. So what do I mean by resources? I am talking about not the home you live in. There's an exemption for your home. But say you had secondary property. If you had another piece of land, I don't know, somewhere in, rural Missouri, or you had it in another state, and it was valued at over that amount. If you were a married couple, if it was valued over $2,000, that would count against you. If you had an IRA, a 401k, bonds, stocks that totaled over this amount, you will not qualify for Medicaid, okay?
What about a car?
Cars are exempt. One car, exempt. They'll ask you how you use it. All these types of questions are on the Medicaid application itself. They're going to ask you a lot of personal information, how much money you make per month, whether you have a checking account, whether you have a banking account, do you own property, have you transferred any property within the past 5 years? And so they will look at and examine all those things to determine whether or not you are eligible.
How does the transfer of property work? What would be an example of that?
Can you hold that thought till I get to the slide on the nursing home? And then I'll talk to you about, remind me that you asked about transfer of property. Okay. And then on the permanent and total disability, that's what the PTD stands for. You would qualify for this category of Medicaid. All the other eligibility factors remain the same, but you're qualifying based on the fact that you have a disability. You'll probably hear Mr. Bunten, Jeff's going to talk about Social Security disability and what it means to be disabled under that law. The state of Missouri follows the same criteria as the Social Security Administration. So they're looking at someone who cannot engage in what we call substantial gainful activity due to a medically determinable impairment that is severe, whether it be physical or mental, and that impairment must have prevented them from earning that substantial gainful activity level of money, and that changes each year by the Social Security Administration, for a period of 12 months or more. So Jeff probably is going to make it simpler than what I just said, but that's basically it. That's basically the standard that we're looking at. Yes, ma'am?
So if it's a disabled child that turns 18 or 21 or whatever the age is, the parents' income and resources come into effect, or just the disabled child?
It would be, if you're going for this category of Medicaid, it would just be that disabled child's income that they're looking at, because they're now an adult, 18 or 21. It's different when they live with their parents. And then that if they had a disability when they were younger, then they would be under a separate category of Medicaid, not MHABD. Okay? All right. Yes, ma'am.
From the time an individual turns in an application for Medicaid, for whatever reason, till they get it is what period of time?
Okay, great question. Thank you for reminding me to talk about that. For old age assistance or based on age, there's a period of 45 days that the state has to process that application. For people with disabilities, the state has 90 days. So what happens, do you think, when they fail to act within that time period? Really nothing, unless you complain. And that is a basis of asking for an appeal, is that there's been a delay in processing your application. There are different things that can process the delay. So within that application process itself, after you file an application, it's not uncommon for the state to send people what is called a request for information. And they will give you 10 days to respond. So typically what happens with clients I've represented in the past, if they're applying based on age or if they're applying based on their disability, they get a request for information and they will ask them for these pieces of information for verification. So they're going to ask for bank statements from the last 3 months. They want to know, and I'll tell you why the 3 months is magical here in a minute. They want bank statements from the last 3 months so they can see what the balance was in your accounts that you identified on your application. They may ask you if you listed a source of income, say you were working and you stopped. They may ask you for verification of when was when your employment ended. So those are examples of what they might ask for in a request for information. Also, the state will ask somebody applying for Medicaid on the basis of disability whether or not they've applied for Social Security disability. And the reason for that is that there's a federal law that requires applicants for Medicaid to apply for other categories of assistance for which they may be eligible. And if a person fails to apply for Social Security when they apply for Medicaid, that can be a grounds for rejecting that application because it's a requirement that they do that they apply for both, basically. Okay?
Does that 45-day or 90-day period stop people while they're waiting to receive information? In other words, what would stop them from saying, well, all of a sudden we need more information?
So if I understand your question correctly, when you apply and they ask for the information, it does not stop the time. It doesn't. The 45 days and the 90 run. So if they don't get a response from you when they send the request for information within the window of processing time, you fail to give it in 10 days, they will deny your application. And they'll say, fail to provide requested verification. Yeah. So one, I think, good piece of news for people who are applying for Medicaid is that recently there was a law that was passed in Missouri that is going to raise these resource limits. They haven't been raised in like forever. I can't remember the exact date, but it's been a long time. They haven't raised it. And I want to say they haven't raised it since the program started, but I could be wrong. But as of July 1, 2017, the new resource limit for a single person is going up to $2,000, and for a married couple, $4,000. And then it's going to increase annually until it reaches like a maximum limit of $5,000 for a single person and $10,000 for a couple. And that is going to be phased in all the way up until fiscal year 2021. So, let me go to this slide, and then I'll back up and go back to the other one. When you get Medicaid coverage, it is not as though the state is just automatically going to pay all your bills. That doesn't happen. There's limitation on what services are covered. And then for individuals with a certain amount of income who say they applied, say you're 65 or older, I applied, I need Medicaid because I need another form of health insurance. Which, by the way, you can have another form of health insurance and Medicaid at the same time. Some people don't think you can do that. Yes, you can. But always know that Medicaid is the payor of last resort. So the state is not going to pay your medical bills if you've got some other form of medical coverage. But for individuals who apply for Medicaid and they have income of a certain amount per month, they may have to do a cost sharing, which is called a spend down. So right now for 2017, and this changes in April of every year, April 1, the amount. An individual with $855 or less does not have to pay a spend down. A couple with income of $1,151 or less does not have to pay a spend down. If you get $1 over that, you are going to have a spend down. okay? Which means that, and the way I've explained it to clients in the past is that the state views it as you having a certain amount of money that you can use to contribute to pay the cost of your own health care. That's the way I describe it, a spend down. So I'm going to back up. So that other slide, the previous slide, slide 14, shows that there's this income maximum that changes every year, and they do an adjusted gross income. And there's a specific calculation, and I'm not going to bore you with the details. I've done many spend down budgets, and I have to try to explain to people why their spend down is X amount of dollars every month. And you have to meet that spend down every month in order for your Medicaid to be active. If you don't meet your spend down, your Medicaid is not going to be active. You won't have active coverage. Yes?
Would that be personal bills as well?
Um,
I'm paying for my sister's medical
Bill.
health insurance. Does that constitute income?
If you are paying it directly to the provider,
Right.
then they normally, generally, the state doesn't look at that as income to your sister, okay? But if you were to just give her the money, yeah, they're going to look at that as income. Yeah, and I will say for spend down purposes, when I say meet your spend down, it's a complicated concept because either you can agree if you're on a spend down to pay directly to the state your spend down every month. It comes out by automatic transfer. If not, then what would have to happen is that you would have to accrue medical bills each month that meet or equal the amount of your spend down. So say, for example, I have a $500 spend down, okay, because of my income. I have to have $500 worth of medical bills every month that I, Karen Warren, am personally responsible for paying. And I have to show documentation that it's being billed to me and there's not a third party like my brother who's going to pay it, or there's not another like human service agency that's going to pay my spend down. I have to personally be responsible for paying that for them to consider that to count for me to meet my spend down.
How do people that don't have family and are definitely aging, is there someone appointed then by the state if they are on Medicaid that will oversee this?
Well, I mean, for many of my clients who are seniors and just because and they're elderly, a lot of them can still handle their own affairs. I mean, they're not incapacitated, they're not incompetent. They are doing this themselves, which can be a kind of a daunting task because you have to, if you don't get it automatically withdrawn, then you have to submit it every month to the Family Support Division for processing. And so they can activate it. Some seniors, if like they live in like a senior building or something, a lot of those places have social workers that will help or case managers. Some people will. But I've had several clients who are on their own and they're trying to do this.
Because we're my aging mother lives with my husband and I. And everything is great. No need for this, but if she would take a turn to where I could no longer take care of her, then looking at the Medicaid, but then if something were to happen to me, the facility, everything would be set up properly like that.
Right. Okay. So the next thing we're going to talk about is part of the Medicaid application process itself. It's called prior quarter coverage, which means that when you apply, there's a box on there that asks people if they want to be considered for eligibility for payment of bills that they acquired or incurred the 3 months prior to the date of application. That's all this means is prior quarter coverage. So say I go and apply in April. I applied this month for Medicaid. I can check, I want the 3 months prior to application to be considered. And if I'm approved, they may pay for bills I incurred in January, February, and March. Okay, as long as I met the financial eligibility criteria and I met the other criteria, either I was 65 or I had a disability. Okay, does everybody kind of get that? And I always encourage people to do it if they have outstanding bills and they don't know how they're going to pay them, because that does happen when people are uninsured. So the next category is Mo Health Net for nursing care or vendor, and this gentleman asked me about property transfers and how that works. This becomes an issue, particularly with this category of Medicaid, because in this instance, the state is paying a third party for your care. They're paying a nursing home provider for your care. And they look, because federal law requires them to do this, the state to do this, part of the federal Medicaid program is that people are not allowed to transfer assets within a set time period in order to become eligible for Medicaid. And that's a big no, because there's a presumption that any transfers made in the 5 years prior was done for the purposes of you becoming eligible for Medicaid. And so that's why they asked the question on the application. I will say that there are ways to transfer assets without it really counting against you. That is not my specialty at all. Other people know more about that law. It's another portion of Medicaid law that is far more complex. But in generally speaking, if you were to transfer property prior to needing the nursing home coverage, the state is going to look at that. And if they determine that it's not a transfer that was acceptable, then what they will do is penalize that person for having transferred the property. And there is a special calculation that they do. Again, with the math, the numbers, I'm like, oh, I went to law school to avoid numbers, but they do calculations. And depending upon how that turns out, there's a set period of time that that person would be ineligible for Medicaid coverage in a nursing home. So that's why the property transfer matters.
Is it just for nursing home application?
It is for a nursing home.
Not for regular application?
Not for regular, but they're going to ask you about the transfers on the regular Medicaid application.
So with in the timeline for acceptance, of course you don't want to say, no, he didn't, if he did, if there was a transfer, but if it takes forever to get, I mean, is it that odd to just apply a few months prior to that, when you know you're not even going to have it at the coverage fee?
Well, yeah, it is. People do apply earlier, and they may have things that they have to get rid of. They may have to spend down, so say they apply and they're over the resource limit. Say somebody had money and they had it set aside and they thought there was going to be enough for their nursing care, and it wasn't. So they spend it all. But when you file any application for any of these benefits, you want to be completely honest, because there are fraud provisions on the application, and you have to attest that you know that to lie on an application can result in a criminal penalty. So you want to be upfront about it. And so say you were a single person, and then you had a bad accident, you were severely disabled, nobody can care for you, you have to go into a nursing home. And then you had like $10,000 at the time that you applied, and you put that on the application. But by the time the application is processed, you've spent all $10,000. What you're going to have to do is be able to explain to the state what you did with all $10,000 of that dollars. So I always tell people, if they're in that kind of situation, you want to keep documentation. You really don't want to have transferred it to like your Aunt Sue so she can hold your money for you. You don't want to do that, because they don't like that, and they're going to look at it. But say you had medical expenses, maybe you needed to buy like a specialized hospital bed, you had to pay for doctor's bills, that's totally acceptable, but you have to show what you've done with the money, okay?
I know you asked to do it, so that's specifically for nursing home.
I'm sorry.
You said it specifically for nursing home.
Yes, that is where they look for it, as nursing home. But I will say this, even if you're applying for the aged, blind, or disabled, and you're not nursing home, you have a large sum of money, they're going to want to know what you did with it. Because if you declared that you had it and you spent it, they want to know what you did with it, okay? I'm going to kind of speed up because I'm looking at my time and I have to get to Medicare. So Medicaid participants have responsibilities to report changes. They also have to pay some nominal co-payments for like doctor's visits. So now we're going to get on to Medicare. And here again, we talked about what the eligibility criteria are. And we're talking about age 65 or older, individuals with certain disabilities like the Lou Gehrig's or end-stage renal failure. Medicare has two kinds of enrollment, automatic and then the kind where you have to affirmatively take steps to get yourself enrolled. Certain people get automatically enrolled, and those are people who are who are 65 years of age and receiving Social Security benefits or railroad retirement benefits. I don't know why they did this designation, but that's just the case. And then also, people who are younger than 65 with a disability, they've been receiving it for 24 months. They're automatically enrolled in Medicare, and so are people with ALS, okay? They're automatically enrolled. So they don't have to take affirmative steps.
What is ALS?
Lou Gehrig's disease. That's just it's a long medical name, which is I can't pronounce it.
Lateral sclerosis.
Yes, this gentleman just said it. Oops, let me go back. So other people have to take affirmative steps to enroll. And those are people who are not getting Social Security benefits. They're age 65 or older. And then also the individuals with end-stage renal disease also must sign up, but not the people with Lou Gehrig's disease. I don't know how they make the designations, but that's what has to happen. Right. And so the Social Security Administration handles Medicare enrollment. And you can enroll for Medicare by going online. Social Security likes you to do a lot of stuff online, ssa.gov. And you can enroll in Medicare that way. You can also make an appointment and visit your local Social Security office. But say you're going to turn 65, you have an initial enrollment period, and you want to try to enroll at that time, and that is 3 months before you turn 65, the month that you are 65, and the 3 months after. So you have a 7-month initial enrollment period for Medicare, okay? And you also have a specific enrollment period. So the general enrollment period is January 1 through March 31st. And usually this is for people who are just trying to, within that time frame, make some type of changes. And then we have special enrollment periods. And then for Part D of Medicare, we have a special enrollment period for that. And Part D is the prescription drug coverage. So we're going to talk about Medicare's 4 parts: Part A, Part B, Part C, and Part D. And every part corresponds to what type of service you're going to get. So that's the best way to explain it. A is for hospital insurance. B is the medical insurance, so doctor's visits, that type of thing, tests and things like that. C is what we use for Medicare Advantage plans. Yes, ma'am.
I just want to make sure that you're not required to enroll for Medicare when you're 65 if you have other insurance. There are certain exceptions. Like if you have creditable coverage, they have specific rules on that. I would say just make sure you contact them, and the reason I'm saying this is because Part B can be a little tricky. If you don't take Part B when you're eligible for it and you delay it and you enroll late, you can face a penalty. So I always encourage people, even if you have other health insurance and you think it's creditable, there is a form that Social Security requires to be completed. Like say you had employer-sponsored health insurance, then you want to make sure you have the right form and that you get that into them, okay? And you have documentation. So just to be cautious, because I have had a couple people, at least in my time practicing, who have faced that Part B penalty because they didn't enroll when they should have. And they believed that they had, credible coverage, this other insurance, so they didn't have to do it. So I always just say, be cautious. Yes, sir?
What might the penalty be?
10%. It's going to be of the Part B premium, and I think it's for as long as the period of time, like where you could have enrolled in it, but you didn't. And so you don't want to do that because the Part B premium itself is, for most people right now, is $109 a month. For people with higher income, it can be higher than $109. I can't remember that exact figure. So, but that's the penalty.
So is it $10 more a month or $10
It's like,
a year?
it's 10% more a month.
So that would be $10.09 more a month if they had $109.
Yeah, I think so. So
And that stays every year after.
it stays, yes. There's ways to remove the penalty, but there's like there's like really detailed exceptions to how you can get out of the penalty. And I'm only saying that because we've had somebody that recently came to our office that had that situation, and we were trying to see, and I can't remember what the exceptions are, I'm sorry, off the top of my head. We were trying to see if there's some way. So that's why I say that about that. So these are the 4 parts. There's what's called original Medicare, which is parts A and B, and the beneficiary pays his or her own coinsurance and deductibles, and it's a fee-for-service health plan where providers are given a certain fee for the service provided. And I should say, and I want to, that in Missouri, the Medicaid program for the people who are aged, blind, or disabled is a fee-for-service, which means that providers agree to accept a certain rate of reimbursement, okay? And with both Medicaid and Medicare, if you are a participant in those programs, you want to always be sure that the provider accepts those. On the Medicaid side, if you didn't check that the provider accepted Medicaid, you're liable for the bill. And I would venture to say that it's the same probably for Medicare. So you always want to make sure that they take Medicare and Medicaid if you happen to be in those programs. And their billing office should know that because the providers have to enroll and they go through a credentialing process. Yes, ma'am.
These dates here under enrollment, are those enrollment window time periods?
Uh-huh.
And so if your birthday doesn't fall within those months,
You can still enroll. I mean, because you have an initial enrollment period. And then you have a general enrollment period, as I understand it, to do other things. Because sometimes people want to make changes. You see what I'm saying? Yeah, okay. And then Part D is special because that's the prescription drug coverage, and people have to pick a particular drug plan to provide them with prescription coverage. All right. So not to confuse you, but that's it. So when you are turning 65, you have your own initial enrollment period, like we discussed. The 3 months prior to your 61st birthday, the month of your birthday, and the 3 months after. The general enrollment period is for other things. Okay.
Can you sign up for Medicaid, or excuse me, Medicare, without signing up for Social Security benefits?
Mm-hmm. You mean in terms of what are you getting, your Social Security retirement?
Yes.
Yeah, I do believe that you can. Okay.
Are you going to talk about the Medicare Advantage?
I only briefly, because Medicare Advantage is the Part C, which is not the same as original Medicare.
Yeah.
So you're either in one or the other, okay? You're not in both.
According to that, you have to pay for your own stuff under original, but you don't have to pay for anything under
You do pay. You pay a premium for your Medicare Advantage plan. It's not free. But it just means those Advantage plans are private health insurance companies. Like through like AARP, United Healthcare, all those people that market, they can offer Advantage plans. But you're going to be in one or both. You're not going to be in original Medicare and an Advantage plan at the same time. The Advantage is going to provide you with everything that A and B would have provided. Okay?
You don't have to pay any co-pays or anything?
What, in Advantage?
You must pay co-pays.
I think it depends on what plan you get in. So you have to find the plan that's best for you. Okay? And then on the Advantage plans, most of them do have Part D included in it, but sometimes you may have to, you might have to go outside to get a Part D plan for the drug, prescription drug. Does that answer your question? Yeah. Yeah, it's not free. That's what I can tell you.
Isn't it subsidized by the government? Don't they pay an extra 14% or something for this plan?
Not that I know of, and unfortunately I did not study like that side of it.
They are free.
Pardon me?
There are a lot of them are free. AAPR is free. Essence is free. There's some.
Okay. Are we talking about Advantage plans or are we talking about Part D plans? Because there are.
With them at the Advantage.
Okay.
But our understanding from a couple of years ago, because we decided to go with the other because the government was having to pay an extra 14%, and we didn't feel good about that.
Okay.
And now we're seeing some of our friends have Advantage plans that are getting some benefits that we're not getting.
Okay. So what I'm going to tell you is, because I don't specialize in that side, I mean, I know about the eligibility criteria, is that there's a great group at the end of my presentation in the resources. And it's the State Health Insurance Assistance Program. Every state, all Medicare beneficiaries have to have access to that. The government requires it. Those people are excellent in counseling you in terms of what plans are available and what the benefits are and what your options are. Okay? So the responsibility of Medicare beneficiaries, like I said, you may have to pay some deductibles and copays. Most people will have Part A of Medicare without paying a premium, but some people will have to pay a Part A premium, and those are people that have less than 30 work quarters, which is administered by the Social Security Administration. They determine how many work quarters you have. And so those people may face paying a premium. But for both Part A and Part B, there is a deductible that you have to meet. And then, as I say, Part C and Part D premiums vary by plan. The next slide shows you generally what is covered under both of these programs. On the Medicaid side, those are services that the state has to offer, with the exception of dental, which is an option. So there's some mandatory services, and then there's some optional services. And then on Medicare, generally speaking, this is what can be covered. I will say that with both of them, a lot of times with these benefit programs, there are restrictions in terms of what is medically necessary. There are restrictions under Medicare of when you can get skilled nursing care. They have criteria that have to be met. A lot of this involves getting a doctor to say that it's medically necessary. And I'll give you an example more on the Medicaid side, and Medicare for that matter too, because we had a situation like that. When you're transported by ambulance, it has to be an emergency. And in the state of Missouri, for the Medicaid program, has a definition of what they consider to be an emergency. And so you have to meet that criteria. So I've had cases in the past where someone thought that they had a medical emergency, they went, and then Medicaid said, no, we're not going to pay for this because we don't think it met the criteria. So what do you do in that instance? You fight back and you appeal. And you try to get your information together to show that, yes, indeed, it was a medical emergency. You try to get information from your doctor to explain why it was a medical emergency, okay? But just keep that in mind. See, oops, I think I'm almost over time here. I don't want to hog up Jeff's time. So, two programs that relate out of Medicaid to Medicare is something called Medicare Cost Savings Program. And this is where people can get assistance with payment of their Part B premiums if they're low income. And there's a program called the Low Income Subsidy. So they get extra help in paying I'm sorry, I'm talking about two different things, and let me back up. So the Part B premium is one thing. That's part of the Medicare Savings Programs. So there's two programs, Qualified Medicare Beneficiary and Specified Low-Income Medicare Beneficiary. And if you look at the handout that I gave you, it has more information on those programs and what the criteria are. It's that first one that's titled Mo Health Net Eligibility for Persons Who Are Aged. It has those programs on there, and you could look at the eligibility criteria. When I talked about the low income subsidy or extra help, that's specifically for Part D and helping people who are low income afford their Part D premium. But as I said, the premiums for different of those plans vary. So people can get a Part D premium that's very low cost. So what rights do you have as a Medicaid and a Medicare beneficiary? As I mentioned, you have appeal rights. There's different time frames. For Medicaid, generally speaking, if there's an adverse action that's taken by the Family Support Division on your benefits, you have 90 days to appeal. For Medicare, it's going to vary because Medicare has, depending on what type of Medicare you're in, original or the Advantage plan, they have a multi-level appeals process where you have to go through certain steps in order to be heard. And they have an initial step, and then a second, and a third, and a fourth, and a fifth. And my last slide here is helpful resources. And so, ma'am, the one organization I was talking about that can help, the State Health Insurance Assistance Program, in Missouri, that is called CLAIM. And I'm trying to see if it's the fourth one, MissouriClaim.org. And they have counselors that can help you better understand Medicare and your benefits and how to coordinate those benefits and help you find plans and plan information. Okay. I think I'm about 5 minutes over.
Give him your attention and I'll let him introduce himself.
So it's 8:10, so first off, before I say thank yous, I'd just like to ask are there any veterans in the room? Would you please stand up? Would you all join me in applauding these folks for serving our country? So I'd just like to thank the Missouri Bar for inviting me to talk, and I would definitely like to thank Karen Warren for agreeing to speak on the two subjects she did. She knows a lot more about food stamps and Medicare, Medicaid than I do. I know about them because they kind of interact with Social Security and VA law to some extent. But I do appreciate her being here. She is a great attorney and really is passionate about her clients. So we're going to talk today about two subjects near and dear to my heart, and this was billed as a mini law school, so just so you all stay awake, I'm going to do like law school and walk around, because I just think much better. I'm an extrovert, so I am told that I think while I talk, and walking around helps me think. I might ask you a question, so I would listen if I was you, because in law school we use what's called the Socratic method. And the Socratic method, if those of you who are a little older, maybe you remember the movie The Paper Chase, and the Socratic method is Socrates. So just pay attention. I will occasionally look at my notes, but I've given these talks before, and I really love this subject because I really love doing what I have been doing. Social Security I've been practicing for 25 years. By the end of August this year, if I do all the hearings that are scheduled, I will have done about 190 Social Security hearings and VA hearings. So that is because of them, partially, not me. They have made some changes that are making attorneys work a lot harder to catch up their backlog. So here's what we're going to talk about. We're going to talk a little bit about retirement on Social Security. Not much. We're going to talk about the disability program predominantly in SSI. And then we'll talk about the VA programs. There's two main ones, compensation and pension. So, retirement. Karen mentioned you can go online to ssa.gov. And I actually went online today and looked at ssa.gov. It is a well-organized website. It does a nice job. And it talks about retirement, which is a subject near and dear to my heart because it is only 9 years away. So, if you read USA Today, you will know that most Americans are wholly unprepared for retirement. The average amount an American has. Sir?
You said it's only 9 years away.
Yes, sir.
Look, I understand. I'm not getting too personal. How old are you?
I just turned 58.
39. You were checking?
I just turned 58. So full retirement for me is almost 67. It's 66 and 10/12. So, it is not that far away. I will probably continue till 70 because that will maximize my benefits, assuming they don't take it away from me. So, I just want to mention, they have some really good materials on planning for retirement. They have a number of calculators on there. Do not bury your head in the sand. I have actually coordinated a Dave Ramsey course. I don't know if you guys know who Dave Ramsey is, but I'm involved with St. Vincent de Paul at my church. And so I see people in financial need, and Dave Ramsey has a very, very concrete way of dealing with financial problems. If you haven't taken his course, I would advise it. It's great. But don't bury your head in the sand. If you're 55, 45, 35, 25, look at where you're at and start planning, because you will be miles ahead if you just start now. So for those of you who don't know, early retirement, of course, is 62. But for a person my age, born in 59, if I retire at 62, I have almost a 1/3 reduction in benefits. 29 point something %. I don't like that math. Okay, that doesn't work with me investment-wise. All right? So, and if you work till 70, then you get a bump every quarter that you work past your full retirement age. You can go on and find all this out, and you can do the math and figure out where you're at. So, that's really all I'm going to say on retirement. Plan. Go and look at the information Social Security has online. Use some of the calculators. And don't just rely on Social Security. Because the average benefit, are you ready for this? Is about $1,135 a month. Now, that is tax-free generally, but that is not very much money. That is just above, Karen, correct me if I'm wrong, that is just above the poverty level. Not by much. It's within 10% of the poverty level. So you are not going to get rich on Social Security in general. So, let's talk about Social Security, but I want to take you on a little civics lesson. So let's go back to high school. In your high school civics course. So of course we have this thing, well, let's start even further back than that. So Dean, is he even here? Oh, there he is, Dean. So Dean and I actually had a trek with the Scouts in Philmont about 15 years. I know you're looking at me thinking, this guy was backpacking in Philmont. I actually did, wasn't I, Dean? I did, 63 miles in 10 days. So Dean, who ruled America before we had the U.S. Constitution?
Ruled America?
Yes. We were a British colony. What was his name? King George. King George ruled the country because he was a monarch. And if you remember the Declaration of Independence, and then we became the Confederation of States, and then all of a sudden we made the Constitution. Okay? So that's where everything starts, is the Constitution. But you will not find disability, physical or mental impairment. You will find militia in a number of spots, but you will not find veterans. So the Constitution is kind of this big, huge thing that the law operates under. Under the Constitution, then, we have the Congress, and they pass these things called statutes. Okay? So there is a Social Security statute, and Karen and I both live in a world that tomorrow, should Congress or the state of Missouri decide, it's gone. You have no legal right under the Constitution to any of those programs. None. Zero. So we are a creature of statutes. So we got Constitution, we have statutes. What comes after statutes? Mr. Trump had a freeze on these things for 90 days. Anybody want to take a guess? Regulations. And what do regulations do for us? What do regulations do for us? Regulations give a little more detail, interpretation, to how the statute works. All right? Now, below regulations, you have another set of interpretations. What is that called? In Social Security, somebody said court, hang on to that thought. In Social Security, you have what's called rulings. And these are further interpretations of their regulations. In VA, they really don't do those. They sometimes do things called fast letters, which the public may or may not know about. And then, one step further down, there are instructions. So in Social Security land, those are called the Program Operation Manual System. POMS. They really get down to nitty-gritty. They tell the district office people, the people you might meet with, what to do in any particular situation. Statute, regulation, rulings, instructions. All right? Then you come to the court. And the court gets to look at all that stuff. And they get to look at whether the government is following its instructions, its interpretation in the rules, its regulations, the statute, and then finally, if there's a constitutional problem. That's how everything that is constructed by statute works. The court does not have much limitation in what it can look at. It does have some appellate rules it uses. It will always look for the smallest issue to decide a case, and if it can make a decision outside the Constitution, it will choose to do so. It does not want to use its constitutional authority. It really doesn't. Okay, and that doesn't matter which court. So, the legal environment we're currently operating within is a statute that is driven by Congress. So Congress's view on things and the party in power and their particular philosophy drives a lot of these programs. So you then have two things going on with Social Security and VA. Although VA not so much, because it's kind of a different animal. You have what's called administrative law. So you've not only got the Constitution and all these statutes related to Social Security, but then you've got the fourth branch of government, it's sometimes called, and that's the administrative agents. That's all these regulations that when Congress abandons its job and doesn't give them very specific guidelines, and the agency is just supposed to figure it out, then there's this whole body of law called administrative law. And you have to understand about administrative law is there's what's called the Chevron doctrine. What's the Chevron doctrine? In its simplest ways, the Chevron doctrine says unless Congress has specifically stated what it wants to do, and the agency has gone 180 degrees from that, the agency's interpretation, as long as it's reasonable, and they will bend over backwards to find it reasonable, the agency wins. It is very hard to challenge an agency's interpretation of what Congress has done unless they specify. So, you've got this whole body of administrative law. So why do I bring all that up? Well, because I want you to know what you're dealing with in Social Security. And what you're dealing with in Social Security is this concept of substantial evidence. Substantial evidence is less than a preponderance. That means it doesn't even have to be 50%. It just has to be reasonable. So whenever I take a case to court and say Social Security has done a bad job, I am basically saying the decision is completely unreasonable based upon the evidence in the law. That's what you're fighting when you go to Social Security. Substantial evidence. Their decision just has to be reasonable. One of the court cases talks about as long as the evidence supports one of the conclusions that is possible, even if we disagree with the conclusion reached and would have reached a different one. If that conclusion is reasonable based upon the law and evidence, we will not disturb the decision. Judge Grunder, in a decision, said that this involves a zone of choice. That is hearkening back to this Chevron doctrine, where the agency is allowed reasonable interpretations unless Congress has specifically stated otherwise. That's what zone of choice is about. And that currently in the 8th Circuit, which is what Missouri is in, that is the current state of the law. And the commissioner likes to cite that zone of choice a lot when they are arguing cases. So, you then have this thing called the burden of proof. So you've got the standard of review, substantial evidence. Then you have the burden of proof. This is kind of the burden of persuasion. And it is on the plaintiff or the person claiming Social Security disability benefits, or SSI. You have the burden to prove you're disabled. They do not have the burden to prove you aren't. So if you're listening, you should by now understand this is an uphill battle. And the people who are making the decision are the people who wrote the rules. But all is not lost. So, we have two main programs with Social Security. One is the disability program and one is the SSI program, supplemental security income. They have the same definition of disability. It is you are unable to work for a period of 12 continuous months, or you are going to die due to a physical and or mental impairment or impairments that prevents you from doing past work and would prevent you from doing other work. Sounds simple enough. I hurt my back at work. I got workers' comp. Surely, I am a construction lady. I've been a carpenter for 20 years. I don't know how to do anything else. Surely, Social Security will see that I am not retrainable. But they don't. Why don't they? Because this is a simplistic example, but this kind of lets you know where you're at. I asked these folks, do you know the alphabet? Yeah. Can you put it in order? Yeah. Do you know numbers? Yeah. Can you put them in order? Yes. You just met the qualifications to be a file clerk. It does not take a lot of training to be a file clerk. It also doesn't pay what a carpenter pays typically. That is not an issue in a Social Security case, what you were paid before. The only issue is whether you can do something that your education, past work, age would allow you to do on a full-time basis. That's what Social Security disability is about. That's what SSI is about. And you have the burden to prove that.
Do you believe that?
Pardon me?
I mean, that for real?
What? Yes, it's for real.
I mean, okay.
Yes. I just like to talk because I don't get an opportunity to talk to the public. I talk to a lot of lawyers who may or may not understand. But I don't generally get to talk to the public because my friends at church all think that all I do is fill out a bunch of forms and then suddenly there's money in my account as if there's nothing to do. It's just so easy to get Social Security disability. The sad thing is when I started doing this at the administrative law judge stage, 80% of people won. Now, at the initial stage, that has stayed pretty static in Missouri and across the nation. It's been between 60 and 66% of people at the initial level are denied. That's stayed 25 years. That's been the same. The ALJs, however, because Social Security wants to tighten the integrity of the program have gone from an 80% pay rate nationwide to a 45% pay rate nationwide. You can draw your own conclusions as to why that may be, but I am just telling you what the rules are. The rules have not changed all that much. The definition of disability has remained the same from 25 years ago till today. But you have interpretations as to just how disabled is somebody. You have to recognize that it's about a couple things. In fact, it's about three things, really. It's about the facts in your case. I routinely get asked, well, Mr. Bunten, can you predict what's going to happen? And usually my response is somewhat flip, and I tell them I will predict what will happen with their Social Security case if they can tell me what the weather will be in 2 weeks. It is simply too chaotic to predict how a human being, a judge, will interpret evidence from a variety of medical sources, will interpret what the client had to say, will interpret the law and apply those facts and apply the law to those facts. It's just simply too chaotic. You have the intersection of medicine and law. So to defend them, it is rather complex. Doctors do not speak legally. When you go to your doctor's office, he or she is not writing their records, so you have evidence for your disability claim. And many of them, if you ask for an opinion, will tell you, I don't have time for that. I'm not going to give an opinion. Sorry. And that hamstrings the client because the burden of proof is on them. So, let's just talk about a little bit about some of these issues that come up in a Social Security matter. So, step one is, are you working? Sounds easy enough, doesn't it? Are you working? Aren't you working? So, Social Security has what's called earnings guidelines for employees. And generally, if you're earning $1,080 gross per month on a routine basis, month in and month out, you are working. Period. Unless you fit within the exceptions, which are it's charity, it's supported employment or sheltered workshop, or some other reason. What might the other reason be? I'll just give you an example, and I've had about 10 of these cases over the past 25 years. The other is where you have a husband and wife who have worked together in a company, and the spouse, who is not disabled and still running the company, keeps this other individual on so that they can have their insurance, their medical coverage through the company. And so the income is not really income. It's so they don't get cut off of medical care for their serious medical condition. And they just keep them as an employee on the books. So that's outside those exceptions, but I have had about 10 cases where that's happened, where I have the spouse testify. It's painful for the disabled spouse to hear their husband or wife say what a loser they are. And by loser, I don't mean loser that they don't want to be married, loser that I wouldn't hire this person. This person routinely makes mistakes. We have to move work around them. I have to have them come in, but they don't do anything. They can't do anything. I tried. They were very interested in trying. They had motivation, but motivation and ability are two different things. Now, self-employed people, that is a whole nother story. So, if you are self-employed, you get extra scrutiny. My theory being, there were some people, before I started practicing, that played games with whether they were still the owner of the company and working or not. So if you're self-employed, the earnings guidelines apply to you, but then there's two other tests. One is, are you putting 20 hours a week into the business, 80 hours a month? If you notice, that's not full-time. But if you put 80 hours a month, if you were devoting 80 hours to that enterprise, you are working. You have not sold the business. You have not disengaged yourself. You're still working. The problem is at step one, if you're working, they don't care how bad your disabilities are. They don't get to those questions. You lose, period. You're working, you lose. So the third test for self-employed people is very subjective. I have some degree of difficulty believing that someone who has been with the government for any length of time can possibly make a decision as to what somebody's value to the business is. That's the third test. What is your value to the business? Now, if you are the business's only employee, I would say you're critical. But if you're not, I would say those are very difficult judgments to make. And yet Social Security makes them. So, let's just talk about unsuccessful work attempts. Another exception, if you work for 3 months, as I said, there's a very big difference between motivation and ability. I have lots of people who are they just can't get their head around, I'm disabled. They don't want to get their head around it. And they will go try something. And invariably, they call me because I ask them, please keep me informed as to any work you do. And they will call me about 2 weeks, 4 weeks, 6 weeks. I couldn't do it. I got fired. I quit. It was too much. So, free pass at 90 days or less. If you work 91 days, up to, but not past, 6 months, and you leave because of your disability, you can also call that an unsuccessful work attempt. So, it's very rare that everything aligns, but court, statute, the regulations all align. If you work 1 day over 6 months, there is no exception to get you into. You're working. You lose. Period. Severe medically determinable impairments. So, as I said, we've had some major changes. So, you might want to write this down, if I can find it. So, Social Security, then, just like all federal agencies, they have this thing called the Federal Register. Think of it like a newspaper for regulations and what the agencies are thinking. So they just made one on evaluation of medical evidence. So the way the Federal Register is, it's a volume. So it's 82, Federal Register, 5844, January 18th, 2017, effective March 27th, 2017. So what are they doing with that one? So if you look at your outline, you will see that I have acceptable sources of medical proof. And I have MDs, DOs, and licensed psychologists. And it has been those big three for 25 years. They added school psychologists and speech and language pathologists about 10 years ago. They have now, in their infinite wisdom, decided that advanced practice registered nurses and physician's assistants can now be acceptable sources of medical evidence as of March 27th, 2017. Advanced practice registered nurse, APRN, and physician's assistants. And their rationale, they always give a rationale, so they always propose these regulations. It's called notice and comment. And typically you get at least 90 days, sometimes you get more. But they published this and said, hey, we'd like to hear your comments. And they get comments, and then they are obligated to respond to the comments. And they usually group the comments together in terms of subject matter. And they indicated that because of the uniformity of regulation around these individuals, that they were going to consider them acceptable sources of medical proof. So, you need one of those how many are there now? 1, 2, 3, 4, 5, 6, 7. 7. 7 groups of individuals. You need one of them to say you have a diagnosis. That's what step 2 is about, is diagnosis. Yes, ma'am?
So is this in Missouri only, or is it federal?
No, this is a federal program, everywhere. And that was one of their comments, because some people were saying, well, what about professional counselors and licensed clinical social workers? And their response to that was, while the APRNs have rather uniform guidelines, as do the physician assistants, the rigor and standardization and educational background for licensed clinical social workers nationwide is not so uniform and rigorous in all 50 states. So they declined to add those folks at this time. So you need a medical diagnosis at step 2 from one of those 7. So we talked about rulings, and I gave you an example of some rulings. One is on obesity, and one is on interstitial cystitis, which you will learn more than you possibly ever wanted to know about that particular impairment if you read that regulation. And I've had some clients who've had it that sometimes the judges forget that these rulings are around. That's part of what you do as a lawyer, is help the judge, because there's lots of stuff to remember. So, but interstitial cystitis sounds like, well, it doesn't sound so bad. It's bad if you have gotten that diagnosis. It can really affect your physical ability to engage in work, and can be extraordinarily painful, and can affect your mental functioning. So then we go on to step 3, which is kind of a combination step. At that level, what they're looking for is whether you have findings that are in their regulations relative to various medical conditions. So it's called the listing of impairments. And this is part of their regulations. And it is medical findings that are required, and I don't want to use the word presumed, medical findings of sufficient severity for them to rate you disabled. And it's a hodgepodge. So some of them are very, very specific, like lab studies, x-rays, exactly what they're looking for. Some of them involve some rather subjective complaints, like restrictions on activities of daily living, difficulty with personal care. Those are not typically things a physician is going to see when you come into his or her office. But those things are also included in the listings. If you don't meet a listing, which most people don't by the time they get to me, then they formulate what's called your residual functional capacity. That is your physical and mental abilities with regard to work. It's the 7 strength demands: lift, carry, sit, stand, walk, push, pull. Everything else is non-exertional. So you have postural limitations: kneel, crouch, crawl, stoop, bend, kneel. You have manipulative limitations: reach, handle, finger, feel. You have environmental limitations with regards to wet, humid, hot, cold, dusty, dirty, noisy. And then you have the non-exertional mental impairments. And just to make things interesting, they changed the mental impairments as of, they just keep making it interesting. So this is why I love being a lawyer, though. It's never a dull moment. Everything's changing. So they changed those as of January 17th, 2017. And no, well, not that I know of. They do follow people around. The Office of Inspector General does go and videotape people. They have videotaped attorneys before. I don't know whether they videotaped me. I'm sure when I retire, I'll make a FOIA request and find out. But I really don't care, because they kind of know what I think. I just want to present my case in the most favorable light, advocate for my clients. I don't have anything to hide with my clients. They are disabled. They have difficulty working, and I'm there to assist them in advocating their position. So, Your doctor, as I said, does not put this stuff generally in your medical records. Yes, sir?
Well, the listing of impairments is included in the federal regulations.
Correct. Yes.
Section that covers.
It's in 20 CFR, Part 404, Subpart P, and then there is, what, Karen? 15 sections? And then in each section, there's different diseases. My wife jokes around when I started doing this that if you read medical records long enough, you'll start thinking you have a lot of symptoms. Wow, I might have that. And you sometimes run into relatively rare conditions. And you're like, I wonder if I could have that. So you start reading things, but you also get to read medical notes. And my two sister-in-laws are both physicians. They say that I am dangerous. I know just enough to be dangerous with medicine. Don't ask me to treat anybody, but I can read medical records. So, and you need to be able to read them because sometimes there's little gems in there. Sometimes they do write, patient having difficulty with daily activities, patient having difficulty in office with mentation. Sometimes they write these little mini mental status exams, and I know my dad had dementia, and one of the gross tests that they do is they tell you 3 things, tell you to remember them, and in 5 minutes ask you, how many can you remember? So if you can't remember them all, you're impaired in some way, okay? So that's a rather gross test. It's not an IQ test or a test of memory, but it kind of lets the physician know if something's going on. So these non-exertional impairments then require vocational expert testimony based upon their own rules and based upon court interpretation. Because they have this thing called the Medical Vocational Guidelines, and everybody refers to it as the grids. So what does this grid look like? Well, it lists work as sedentary, light, medium, heavy, and very heavy. That's the exertional. And then it goes down on the left-hand column for each of those exertional areas and talks about how old you are. And Social Security divides it into younger individuals. So that would be anyone under 50. Then you have 50 to 54, which is a category. Then you have the category I'm in, 55 to 60. Then you have a category of 60 to 62, and then you have a category of 62 to 65, because they haven't kept up. So, and each one of those categories, and please don't take this wrong if you were in one of those categories, but what they look at then is your educational background, what your past work has been, whether it's been skilled or unskilled, and they ask themselves, could this person make an adjustment to other work? And the basis of the grid is, the older you get, the less vocationally mobile you are. If you would like more of a colloquialism, you can't teach an old dog as many tricks. It's written into the law. It's actually quite reasonable. So if you've got someone, that carpenter that we talked about earlier, who's been lifting and toting 50 pounds around and can't do that anymore, and is 55, and all she could do is a sit-down job, and she only has an 8th grade education, she's disabled. Because nobody's going to take a chance on her to train her for 10 years. That's written into the law. Now, they want to change that. They want to raise those rates, which is nice if you have a sit-down job like me. Okay, fine, raise them. But if you're running a jackhammer, or you're an electrician toting conduit around, or pulling and large gauge wires through walls, or my favorite occupation, a plumber, you are lifting cast iron at times and moving things around, you're not going to make it that far. You're just going to give out. So you have to prove you can't do your past work. Past work is defined as work you've done in the last 15 years. It has to be done substantially and long enough for it to count as past work. And Social Security, if they can't tell and you can't remember what you've done in the past, because all they get is these quarterly reports that show corporate employers who have paid your wage taxes in. If you can't remember, then they have a new rule. We'll just dispense with that step, and we'll move on to step 5. So it isn't indispensable that they prove you can't do your past work. They just move on to step 5. And I'm just going to kind of quickly here on step 5. They hire these vocational experts, but recognize the resource that Social Security relies upon and is specified is the Dictionary of Occupational Titles. This is a government publication that has not been published since 1991. It has not been updated. If you write the Bureau of Labor Statistics, they will laugh at you, unless you're writing about Social Security, and then they will completely understand. So they use this resource to prove whether or not you can do work. And sometimes it has interesting results in terms of the jobs they cite. Just recognize they're using an old resource to prove you can do work. So adjudication, you file for benefits. Right now in Missouri, generally if you file, you're looking at 2 to 6 months, you get an answer. You can go online. I would recommend highly, if you go online and you want to apply, write your file number down when you sign on, because it signs you off relatively quickly to protect your privacy. Really quickly. Write that number down, because then you can go back and you don't have to start all over again. Because if you didn't write the number down, you were never going to find it from anybody else. As I said, only 40% of people nationwide are approved. That's pretty much the statistic in Missouri. So then you request a hearing in Missouri. We're one of the prototype states. So about 15 years ago, they decided they would do away with an administrative review called reconsideration. The other 40 states still have it. My theory why they got rid of it was 90% of the people who got denied at reconsideration still appealed. There are a significant number of people, if they get an initial denial, they give up. I've had people, I've asked them before, why did you give up? Well, if my government says I wasn't disabled, I wasn't going to question them. I understand somebody who does not work in the legal system feeling that way, but lots of people don't appeal. So in Missouri then, in St. Louis specifically, you request a hearing before an administrative law judge. That currently is taking on average 18 to 24 months to get a hearing. So if you're counting with me, if you're an optimist, you're at 20 months with no income. If you're a pessimist, which I would suggest you be with this, then you are at 6 plus 24. You are at 30 months. 2.5 years with no income. You can decide whether that is world-class service, as Al Gore said it was, or whether or not you do not feel your tax dollars are being used effectively.
Well, if in order to get it, you'd have to be able to solve the problem. You could be a detective, couldn't you?
Could be a what?
Detective.
What? I'm sorry, I don't understand.
Well, if it takes that long to do, figure out how to get it, and be motivated, I think that would take talent.
Well, it doesn't take talent, but it does take bodies. So this hiring freeze that some of you may think, well, that was no big deal. Great, we don't have to hire any new federal employees. So that applied to Social Security law judges. And just like every other job, if you were new to the job, you are not as fast as when you're old to the job. 40% of the federal workforce is eligible for retirement right now. That is a huge, if you've run your own business, that is a huge institutional knowledge base lost. They will not get faster with new people, they will get slower. Because it's like anything else. As this gentleman just said, this sounds rather complex. It is. And so these new judges, and I've been doing it 25 years, there are only, let's see, 1, 2, 3. 3 judges out of 22 in St. Louis that are still judges as when I started 25 years ago. Everybody else is new since then. And I would say well over half the Creve Coeur office is newer than 2 years. So there is a learning curve for judges. And when you don't hire them, it just pushes it down the road. So you get your hearing in front of an administrative law judge, and as I tell people, they're as different as 22 people you'd meet on the street. They each have their own little way about them, and that's part of what you hire an advocate for, because that's part of the chaos. How does this judge view life? What's important to them? What is a hot button? So you just kind of learn to deal with those and to help your client along with those. If you lose at the administrative law judge level, you go for an administrative appeal. It's just in writing to the appeals council, which is in Falls Church, Virginia. And they currently take anywhere from 4 months to 12 months to make a decision. About 3/4 of the time, it's a denial. You lose there, you go on to federal court. And then you're in that substantial evidence, burden of proof, zone of choice, trying to prove that your client can't work. So, let me just talk a little bit about VA law, because I know it's getting late. And we can kind of make this simple. So, I will just say the things you have read about the VA in the paper, just say to yourself they are 10 times worse, at least, than what you read. The VA is the second largest government agency, behind only the Department of Defense. Now, VA is basically 3 entities under the Secretary of Veterans Affairs, Dr. Shulkin. He's the first non-veteran to lead the VA ever. He is a distinguished physician. He has run several large medical operations privately. He was heading up the VA Health Administration. That's 80% of the employees at VA. The medical centers. I don't deal with them except to get medical records. I deal with the VA Benefits Administration when I'm trying to get a veteran compensation or pension. So let me just talk about compensation and pension. Compensation, if you listen to people talk, sometimes they talk about service-connected benefits. They're talking about compensation. That's the formal name for the program. Sometimes you hear people talk about non-service connected. That is the pension program. Real easy with the compensation program, you need 5 things. You need to have been on active duty. You need to have more than a dishonorable discharge. And it may sound like that's really easy to figure out, but at times those discharges that the military gives do not match up with the VA law. So the VA will make an independent determination as to your discharge status if it doesn't say anything like general or honorable. They will make their own administrative decision whether it was less than honorable. And if it's less than honorable, then you are not eligible for benefits. And then you need to have an injury or event in service, a current diagnosis of a medical condition, and a nexus or connection, generally medical evidence, that says what's wrong with you now is related to what happened to you in the military. So if any of you have had any experience with the workers' comp system, it's similar to workers' comp for veterans, because it deals with percentages. Social Security is all or none. You're either disabled or not. VA is much more like the workers' compensation system. It is based upon percentages. Much like Social Security, they have this set of regulations called the diagnostic codes. The diagnostic codes have what the medical findings are for the various impairments. And that's where you get the percentages from. You can get both Social Security disability and service-connected benefits from the VA. And I have been able to do that for any number of people. And so that $1,100 on average per month, VA, if they have a spouse and a child or 2, they might get $3,000 to $4,000 from the VA. All of a sudden that family has $5,100 a month of income, which is why I love representing veterans. It makes a huge difference. And they have done an extraordinary job of defending this country and my ability to practice law and in protecting our freedoms that we value. I do want to talk about VA math just briefly. So VA math is what's known as the combined rating table. It's at 38 CFR 4.25. It's a regulation. It's actually a grid. And the basis of the grid is an algorithm. And the algorithm goes something like this. If you're rated 30% for something, the next time we rate you for something, we're only going to rate the 70% of you that's left. So if you get a 20% rating on 70, that's not 20, that's only 14. So 14 plus 30 is 44, not 50. 44 rounds down to 40. Now you can disagree with that, but that is the, thank you, Jim. That is the basis for the combined rating table. That is probably one of the #1 questions I get from veterans. You know, these guys don't know how to add in the government. Well, they do. But that is the logic behind the combined rating table. I will just say, if you think Social Security is complex, the VA adjudication process, you could not have gone out of your way more to make it more confusing to people. And even the attorney, I was just in San Antonio last week, even the attorneys who practice in this area, and I was on this board, it's called the National Organization of Veterans Advocates. When I started, it was about 60 people, and now it's about 400 or 500 lawyers across the country who do this routinely. You could not go out of your way more to have created a confusing system. At its simplest, the way it works, let's just say you have one condition. You file. Nothing happens till you file. You complaining about it to your buddies down at the, I won't use the Vietnam veterans because they never complain about anything. At the American Legion, if you complain to your buddies down at the American Legion, nothing happens till you file. You then file and you get what's called a rating decision. So you may find it difficult to find an attorney who will represent you before you've gotten a rating decision. The simple answer to that is, we can't be paid, because Congress wrote it that way, until there's a first final decision. So VA gets the first shot at it. Now, it hasn't always been that way. That's just been the law since June of 2007. Before that, you had to go through the entire administrative process. You had to have a rating decision. Then you had to file a notice of disagreement. Then they had to file their statement of the case. Then you had 60 days to file your VA Form 9. Then you waited 2 or 3 years for the Board of Veterans' Appeals to make a decision, which 50% of the time they send it back saying something wrong was done. And then you start on the gerbil wheel again.
That makes a lot of sense to me.
Now, until 1988, you did have the ability to get an attorney, if you could find one who would work for $10. Because from 1888 to 1988, the fee limitation in the statute, remember those things we talked about at the beginning, the statute? In the statute, $10. And the history behind that was, there were apparently some scalawags after the Civil War, who, because they could read, and most Civil War veterans couldn't, and they could fill out the 2-page form, were charging an exorbitant fee. Now, I don't know what exorbitant was. Judge Stevens on the Supreme Court in a 1978 case, when there was a challenge to this fee, said that in 1888, a $10 fee was about $1,500. However, in 1888, they did not think of this thing called a cost of living escalator. So think about it. Spanish-American War, World War I, World War II, Korea, Vietnam. No attorney representation. So you may ask yourself, well, where did these veteran service officers come from? They came because the veteran service organizations recognized they needed some help. And these guys and gals, because there's a lady who's with the American Legion who's very good. Her name's Tracy Davis, and she is extraordinary at knowing what to help veterans with. So that's how the VSOs came into being, because you couldn't find a lawyer, unless it was a buddy. I mean, if you had a friend who was a lawyer, and that's how some of my friends got involved. They were doing cases for a friend, and saw how screwed up it was and got involved. So in 1988, they created the court because the Vietnam veterans were complaining so much. The Congress finally said, enough. We're tired of the VA saying they got it covered. It is one of the last federal agencies to have court review. Not till 1988 did the VA ever have a court say whether what it was doing was right, either constitutionally or consistent with its regulations. Pension's non-service connected. It's basically you have to serve during a period of war and be totally and permanently disabled. So, I think I have run out of time. I will just say va.gov is not nearly as robust as ssa.gov, but it does give you some information, and the VA wants to go electronic. They have yet to figure out how to get attorneys electronic, but they are working on it. They are close. The veterans can actually get on electronic. You can go on to e-benefits with the VA and actually find out quite a bit about your claim if you're a veteran. So I don't know if you have any more questions or not. I've run a little over, but I'd be glad to answer any questions about VA and Social Security.